Okay, excellent. So if we can move into the slides here. Overview of what we're going to do today. So we're going to talk a bit about the special education laws and regulations that are in place. These are what provide the rights to students with disabilities. We'll talk about transition from preschool early intervention to school age. What's supposed to happen in that transition, and in our experiences, where are some of the kind of hangups that happen in that handoff? Well, then we'll go more generally into identification and evaluation processes. What is necessary for an appropriate evaluation? What goes into an appropriate IEP? How do you know if what your child is receiving is appropriate? And then finally, we'll talk about timelines that are necessary under special education law and fundamentals of that appropriate IEP. And there's just a little graphic that was on the last slide for anyone who may be visually impaired. So that was just a gavel and says your educational rights there. That's our goal for today, is that you leave knowing the educational rights that your child has. Some terminology. So anyone who spent a little bit of time in this field knows that it is all about acronyms. It is just alphabet soup out here. So EI, early intervention. And by that, we are really focusing on the preschool early intervention from 3 until the age of beginners for school, and less so about birth to 3 early intervention services. So we're focusing on the preschool. 3 to 5 is about typical age-wise, or 6. Then IEP, Individualized Education Program. So that's the document that provides the services and maps out what they are supposed to be for a child, whether they're in early intervention services or whether they're in school age services. The LEA, for a school district or a charter school, that's a local education agency. They're the person responsible for providing the services. So for school age, you're really looking at like whether you have a school district, charter school, cyber charter school as your local education agency. For preschool early intervention services, that's often an intermediate unit or another entity who is responsible for providing those services. We'll talk about NOREPs, or prior written notice. So a NOREP is a notice of recommended educational placement. That is that form, if you've ever received it, that asks you to either approve changes to the child's program or say that you do not approve, and gives you some options if you do not approve, like mediation or due process to check. FAPE is the general entitlement that we'll be talking about. What is it that students need to get? It's FAPE, a free, appropriate public education. And we will go into detail about what that means for a child to receive a FAPE. Related services is a term that covers a whole lot of services out there. Most people kind of know them as, speech, occupational therapy, physical therapy, but there are others as well. It can include counseling, transportation. It can include parent training, a lot more than what maybe is typically discussed. And then the last one that we'll reference is least restrictive environment, or LRE. That's a child's right to be with non-disabled peers to the maximum extent appropriate. So we want to see students with disabilities educated in the places where their non-disabled peers are when they are able to do so, but the law understands that that's not appropriate for every child. If it's not appropriate for a certain child, they may need something that is a more restrictive environment. Moving on to just the transition phase from preschool early intervention to school age programming. And this is just a big one. It's a big one in a child's life. Thinking of moving from preschool to school age programming. And it has some big shifts that come along with it in terms of what the programming may look like. In an ideal world, you see this kind of happen in kind of a smooth way where there's a lot of communication and the child's needs are going to be met from day one within their school age programming. Unfortunately, that doesn't always happen. So we'll talk about some of the snags that may be hit at times. So preschool early intervention services to review are available for age 3 until school age. Usually they're provided by intermediate units for the county in which the child lives, but for Philadelphia, that's provided through Elwyn. So again, usually not provided directly from the child's school district, but rather from the county. Children are eligible for preschool early intervention services if they exhibit a developmental delay of 25% or greater, or they have a qualifying disability. So those are two different things. I sometimes hear that parents have been told that it has to be 25% or greater delay. That's not true if there is a qualifying disability. So those are two different ways to qualify. And then the second piece of it is that they must require specially designed instruction because of the delay or disability. Transition does not have to occur the very first year that a child is eligible. So this is a big decision for families to make. And what you may want to think about is, where is your child right now in terms of their readiness for school age programming? And, what may be different for your child in terms of moving into a school age program versus staying within the preschool early intervention programming. What I will say should not be the driver in this discussion is something like, well, you may hear from your early intervention provider, well, we don't provide X. If you want that, you have to go to school age. Either provider should provide what the child needs based on their disability. So whether a child is in preschool early intervention services or they're in school age, they should be getting what they need based on their disability to have a free, appropriate public education. When a family is hearing, well, if you want that, you better move to the school district or you better move on to school age, that's kind of a red flag for me because that does not necessarily have to be the case. A child needs to be met in either setting. Early intervention services can continue until what we call the age of beginners. And that's the minimum age established by the school district's board of directors for admission to the school district's first grade. So usually there are about 2 years that a family may be considering transition. They may consider it at the earliest availability that they would be moving in to school age programming the year that the child is 5 years old, or they may be considering it the year after. That's the most typical scenario. The law requires that this transition happen without interruption to the program. So we absolutely don't want to see a child who's getting services, needs those services, making progress with it, and then because of this transition, there's a big gap, they have regression. We want to see, ideally, this kind of seamless transition happen. And what needs to occur for that is that the early intervention provider, the family, and the school age provider are expected to work collaboratively so that everyone has enough information and everyone can get that plan in place. Timeline-wise, just kind of generally, by February 1, parents should receive the notice explaining that there is a transition process and giving them information about it. Parents of a preschool early intervention child, that is. By the end of February, the early intervention team would then convene a transition meeting if the child is going to be transitioning. So records are going to be shared at that point from early intervention to the school district or charter school. A representative from the school age programming should be attending, and parents will get the intent to register form. That form is the thing that starts the school district or the charter school's responsibilities to say, okay, we're aware that there's a child with a disability who is enrolling within our schools. We got to get moving so that we have a program ready for that child when the transition happens. The parents and the school age IEP team can decide whether they're going to adopt the preschool IEP or whether they're going to revise it. Often at this point, kind of in the spring of the year before, the child's going to start school age programming, there's going to be a discussion about whether to reevaluate. And I absolutely highly recommend doing a reevaluation, even if the last evaluation that was done by the intermediate unit or preschool early intervention provider was fairly recent, because children change so much at this time. And also the things that a school age evaluator may be looking at and focusing on in terms of providing special education services within a elementary school may be a little bit different. So between the fact that the child really may look different within even just 6 months, and the fact that the evaluators may be honed in on different things, I absolutely recommend getting an evaluation. So either agreeing to it if it was requested of you, or asking for it if it wasn't. So after that intent to register form, but no later than April 15th, that school district or charter school should notify the parent in writing and begin that transition process. An IEP generally be implemented no later than 10 school days after its completion. And this one's so important. An IEP has to be in place before the start of the school year. And that's one that I do really see as one of those snags, is that many times everyone's aware that there's a child with a disability who's incoming, but the parents may hear things like the IEP team can't meet over the summer, or, they may have a, recognition from the school district that we understand that this child has an IEP, but no formalized document that is in place to say whether they're adopting the preschool IEP or they're revising it. If at some point you find yourself in that kind of no man's land, it's really important to understand that there should be an IEP in place for the very start of the school year, so that the student on day one is receiving a free, appropriate public education. Okay, students who are eligible for preschool early intervention, then they are going to remain eligible unless a reevaluation determines they are no longer eligible. So there would have to be an actual reevaluation and then a determination that says, no, your child no longer qualifies, if that were the case. That does happen in some cases where a child, was qualifying as a preschooler and no longer qualifies. It's definitely something that parents should watch out for. Parents should get a NORAP, that notice of recommended educational placement, if there is a decision that the child no longer qualifies. And if the parent disagrees and they want the child to continue to qualify and have an IEP, it's really important that they timely act upon this. So that would mean that they respond to that NORAP saying, no, I do not approve the recommendation to exit the child from special education, and also that they file with the Office for Dispute Resolution in Pennsylvania to say that they want mediation or due process. So that's really important that both of those things be done, because what happens then is that the child is entitled to stay in the last program or placement. We sometimes call it a pendant placement or the stay put, until either that mediation or that due process hearing is completed, and they will continue to receive those services while there's a dispute. It all has to be done within those 10 calendar days, but the good news is that returning the NORAP is usually fairly straightforward, and filing for mediation or due process is actually a very easy, accessible process through the website for the Office for Dispute Resolution. At the end of this presentation, we will talk a little bit about how that is done.
Okay, so now we want to talk a little bit about how a student is identified as one who needs special education supports, more details about how that evaluation takes place, what it's supposed to look like. And again, apologies in advance if you hear my dog barking in the background. He's not doing his best right now, apparently. Okay. So A local education agency, or an LEA, as Jackie said earlier, must locate, identify, and evaluate all children who are reasonably suspected of having a disability who require special education. So it's really important to note that this is the school district's responsibility, not the parents. I can't tell you how many parents we speak to who say, who blame themselves for not getting their student support sooner. And it is absolutely not the responsibility of the parent to identify a student as someone needing special education services. It is up to the school district to identify and find these students. And this includes all children residing in the school district, including those who are in private school and those who are experiencing homelessness. They must locate, evaluate, and identify in a timely manner children who are exhibiting learning, behavior, social or emotional difficulties that are associated with disabilities. So this is another important thing to consider, that when looking at whether a child is suspected of needing special education services, it's not only about those academics that some might think about when they're thinking about special education services. One's access to an education are related to a variety of factors, one being academics and, the grades and how they're reading and writing and performing in math. But it's also related to anything else that can impact their ability to access an education, like their behavior and their social and emotional well-being. So this is what we call child find, the school district's responsibility to find and identify these students. And that must happen within a reasonable time in light of the information and resources possessed by the district. So when they should have known that a student was exhibiting different things that might have made them eligible for special education services. And so, like I said, a parent's failure to request an evaluation does not relieve the LEA of its responsibility to find those students. So some signs that a student might need an evaluation include any of those listed on the slides here, such as struggles in the general education curriculum, lower failing grades. So that's what I mentioned earlier, those more academic signs that a student might be eligible for special education services. But some other signs that might be at play would be behavior issues, truancy. So if a student is not attending regularly, detentions and suspensions, frequent visits to the nurse, lack of social skills or peer relationships, disorganization, lack of attention and focus. So some of those may go to a struggle with executive functioning skills, a lack of improvement after an RTI. So a parent or a district or charter school, the LEA, can initiate the evaluation process once it has, after seeing one of those signs that we discussed or others that make them believe that a student might be eligible. They can initiate, an LEA can initiate, or a parent on their own can initiate the evaluation process. If a parent makes the request should be made in writing, we recommend. A district or charter school should either agree and issue a permission form or decline and issue a NORA. So the steps in the evaluation process. If the school district does agree to initiate evaluation process, and if they disagree, if a parent makes a request on its own and the district says no, we'll discuss what happens after that shortly. But if the district does agree to move forward with an evaluation, it would then issue a PWN, or prior written notice, for an initial evaluation and a request for consent form, or PWN. Then the parent would return the consent form, signing the form and giving the school district permission to evaluate the student. Consent is required for this initial evaluation. So a school district can't evaluate your child if you don't want them to. But not required if a parent does not respond to a request or a reevaluation. So if you respond to saying no, then the school district cannot evaluate the student. But if you don't respond, that consent's not necessarily required. So make sure you respond when a permission is issued. An evaluation, assuming that consent is given and the evaluation moves forward, an evaluation must be completed and issued to the parents within 60 calendar days from the date the district receives the signed permission, excluding time when school is out of session during the summer. Reevaluations occur every 2 years for a student with an intellectual disability, or every 3 years for a student with any other disability.
Yeah, and one of the things to highlight about that reevaluation timeline that Rachel just explained is that because summer is not included in those 60 days, it's really important for parents to kind of understand when an evaluation is going to be due. So in this transition process that we're talking about, if a permission form is not provided to the family early enough in the spring of the year before, there's a possibility that the reevaluation wouldn't even be due until partway into the new school year. And that can be one of those situations that produces that kind of snag or puts that child in limbo a little bit, where we're waiting on evaluations to create that school age program, but the timeline is such that it's not even going to be due until like late September or early October. So, being proactive about getting that reevaluation permission form in the spring, and potentially, making sure that you sign it and you return it. Or if it's going to be due in the fall, maybe having some upfront conversations to say, is there any way that this could be kind of expedited? Because I know that my child needs an IEP in place for the start of the school year.
Thanks, Jackie. So when a school district does conduct an evaluation, it's required to be sufficiently comprehensive to identify the student's special education and related services needs. This means that the evaluation needs to comprehensively or on a wide scope evaluate a student. It can't just, or it shouldn't just look into one specific area. It should be comprehensive to make sure it's really getting, really evaluating the student's whole academic, social, emotional functioning, and how they would then be able to access their education. So to do so, the evaluation report needs to use a variety of assessment tools and strategies to gather relevant, functional, developmental, and academic information about the student, including information provided by the parents. So this will involve a range of assessments, cognitive, achievement, behavioral. It will also include parent input, so they can get a full sense of how a student is functioning. So like I just mentioned, it should not use any single measure or assessment as a sole criterion for determining whether a child is a child with a disability and for determining an appropriate educational program for a child. So an evaluation should not look at just one assessment and say, because of this assessment, the student doesn't need special education services, if a variety of other things would imply that the student does need special education services. It needs to look at the full picture and be holistic. The evaluation should also use technically sound instruments that may assess the relative contribution of cognitive and behavioral factors in addition to physical or developmental factors. Now, if a district's evaluation is not comprehensive, so it doesn't review everything that we just talked about, parents may disagree with the evaluation report and request an independent educational evaluation at public expense. So the district evaluations that we've been discussing are conducted typically by the school contracted psychologist. If you don't agree with the evaluation, you can then request an independent evaluation, which would be performed by an evaluator who does not work for the school district. And you can request that at public expense. So the school would have to pay for it. And the district has two options. So if you request the evaluation because theirs wasn't sufficient, the district can either agree to fund the independent educational evaluation, or IEE. That's another one of those acronyms that's thrown around a lot in this context. So they can either agree to the IEE or file for due process to defend its evaluation report. So in that situation, and like Jackie said, we'll talk more about the different, due process and what that looks like a little later on. But in this situation, it's the school district's responsibility to file for due process to prove that its evaluation was sufficiently comprehensive and that they therefore do not need to pay for an IEE. So when talking about, and Jackie touched on this earlier when talking about transition, But when some common issues that we see in evaluations that are conducted when transitioning from early intervention into kindergarten could involve a couple of different things. So one issue we see a lot relate to the environment, because the environment is very different between early intervention and kindergarten, as Jacki already touched on. For instance, early intervention there could be differences in whether it's a full day and full week versus a partial day and partial week programs. There could be different transition for different rooms for specials, smaller versus larger classroom sizes, navigating to a newer, larger building, different bus transportation. There are just a lot of different factors that are in play when transitioning from early intervention to kindergarten or to the beginning age into the school district. So it's really important that an evaluation takes that into consideration when making its findings. So if it doesn't, then that might be an issue in that evaluation. It's also common that a child might need an updated observation or functional behavior assessment, or FBA, when going into kindergarten, for all of the reasons that we've already discussed. And another issue we see in these evaluations is that the evaluation may not have fully assessed academic skills, language skills, attention, focus, or other areas of potential need. And that's because, like we've said, those areas present themselves very differently in early intervention. So when going into kindergarten, there are a variety of different things that might need to be assessed, different types of academic skills, different types of focus is required and whatnot. So it's important when reviewing an evaluation that at this stage in particular, that all of these things are considered. So after the school district does its evaluation, in order to find that a student is eligible for special education services, the IDEA Act, which is the federal act mandating everything related to special education that we're talking about today, lists out a variety, 13 categories that a student who is eligible for special education services must fall into. Now, a student can fall into multiple of these categories sometimes, but in order to find a student eligible, they must qualify under at least one of these categories. So the categories include autism, deafness, emotional disturbance, and that kind of consists of a variety of things that are related to a student's mental health and emotional social well-being. Hearing impairment, intellectual disability, multiple disabilities, which means, so like I said, a student can qualify for special education services under a variety of disabilities. The multiple disabilities category means that a student needs to be accommodated for both of those disabilities. So sometimes if a student has both has autism and also emotional disturbance, the IEP, both of those categories are at play. The services sometimes will cater to the primary disability, but for some students that's not, and for some disabilities that's not possible. The IEP needs to jointly take into consideration both of those disabilities. Some other potential categories are specific learning disabilities. So these are learning disabilities like in areas such as reading comprehension, math problem solving, written expression, those disabilities that affect a student's learning in those academic areas. Speech or language impairment, orthopedic impairment, other health impairments. So this is kind of the catch-all, but one common disability that falls into this is ADHD. Traumatic brain injury is another category, visual impairment, and then developmental delay. So developmental delay is the only category that has an age restriction. In PA, this is only for students in preschool.
Okay, switching gears a little bit to talk about timelines. Knowing the timelines is really important so that families have a gauge of whether the process is unfolding the way it should procedurally. I caution families that often people are a little too tied up in the timeline from a procedural standpoint of, like, for example, should the evaluation have been done in 60 days, but it was 61 days. that might not really be the kind of like substantive thing that's violating a child's rights, even though it is procedurally inappropriate. But really, we want to look at what's the impact to the student. So you have to know what the timeline is to know whether it's occurring appropriately. And then you also have to consider, was there an impact to the student? So difference between 60 and 61 days, maybe no impact at all. Difference between 60 days and 120 days, if a child's sitting in a program that's totally inappropriate for the child or hasn't been identified, absolutely substantively a problem. So we want to look at both what the timeline is and how it impacted the child. Here are some that are important to know. So that evaluation timeline, Rachel already explained, 60 calendar days, but without summer for evaluations or reevaluations. And that clock starts ticking when the school receives the signed permission form. So making sure that if you get the permission form, you sign it and get it back quickly, and that you note the date that you returned it. I am a big proponent of doing as much as you can through something that's trackable for the date. So an email that's attaching a signed permission form is a great way to do this. You can prove when and to whom you sent it. It has a date timestamp, and we know when the clock is supposed to tick. Other things like putting the signed form in, your child's backpack to go back to the teacher become much murkier. If there's a dispute down the road about when the school received that form, sometimes it's very difficult to prove with certainty when it was provided. 30 calendar days after an evaluation is the timeline for the IEP team to meet. So when a family gets that evaluation report within those next 30 days, there should be an IEP team meeting to consider the results. 10 school days before the IEP meeting is the timeline for how long you should have that report in your hands before the meeting takes place, but it can be waived. So if you got the report and you had an IEP meeting 5 days later, but you felt prepared, you felt like it's okay, I had time to read and review all of this and I'm ready to go, I think in that circumstance, it could be fine to sign and waive that 10-day period. If you get the evaluation report the night before a meeting and you feel like this is a huge document, I need to really be able to review it, or I need to review it with an attorney or an advocate or a psychologist, and I don't have time, then there's no reason why you need to waive that 10-day period in that kind of circumstance. And then 10 calendar days, we talked about a little bit before, but this one's so important, so worth reinforcing. That's the time frame for the response to the NORAP. So from when you get the NORAP, you have 10 calendar days to return it to the school district, charter school, or early intervention provider. If you are approving, great, you check you approve, then the program goes into place. If you are not approving, and you're within those 10 days and you file for mediation or due process, whatever the last program is, stays in place, that's stay put. And the new changes do not go into effect at this point. If you do nothing and the child already had an IEP, the changes go into effect. If you do nothing and the child did not have an IEP, this is the very first NORAP you've ever gotten, and it's for the start of services, the services do not go into effect. So there can be a lot tied up in this. If you ever have questions about how to answer a NORAP, not sure why you got one or what to do with it, then you may want to seek timely legal counsel, just noting that you only have those 10 days. So get it and reach out as soon as you can. Other timelines are some for extended school year services. So these are services beyond the 180 days in a school year for school-age students. The Armstrong group of students with severe disabilities, they need to have an IEP meeting for each disability by February 28, and they need to have a NORAP saying what the ESY determination is by March 31st. The non-Armstrong group, so students who don't fall into that group with severe disabilities, don't have the same deadlines. For them, though, it still needs to move in a timely fashion. So the school district does have to consider eligibility for ESY. It should be done basically around the same times that the Armstrong group is, to be honest with you, because that will give the family enough time to be able to dispute the program in the event that the child is found ineligible or the ESY offer is not appropriate. And if a family is filing for due process because they're disputing the extended school year program, then it would be an expedited due process hearing. And those happen very, very rapidly. So the good news is that we don't have to wait, until potentially the end of the summer to find out if the child was eligible for the services over the summer. If there's a dispute, you want it to move quickly, you want that all wrapped up and decided before the summer starts. All right, fundamentals for an appropriate IEP or 504 plan. This is what is a child entitled to, essentially, when they're getting one of these programs. They're entitled to FAPE, the same acronym for both. It looks a little bit different between 504 plan students and IEP students. We're mostly focusing here in this presentation about students with IEPs. We do have other content available on our YouTube page and on our website in terms of articles that focus more on Section 504. Or if you have any very specific 504 questions, we're happy to answer those, and we could be contacted outside of this presentation because this is going to focus much more on IEPs. So what goes into a FAPE for a student who gets an IEP? It's an individualized program, so no cookie cutter needs to be for that student. It needs to be designed to meet their needs, and that is whatever those needs are, whether or not they're associated with the eligibility classification. So if a student with a specific learning disability in reading is also experiencing anxiety, the anxiety-based needs need to be met as well, even though technically they qualify because of their reading needs. And the child needs to receive meaningful educational benefit from these services. So they're not services that should just produce minimal or trivial benefit. It's supposed to be meaningful. It's supposed to prepare them for further education, employment, or independent living. Whatever is going to be appropriate for that child, that's our ultimate goal in the end, to help them achieve that independence. For FAPE, when an IEP is developed, districts are then required to provide notice if there's any changes that are going to be made. So that's that NORAP form that comes home. That could be because a service is being increased, decreased. It could be because of a change in location of a service. It could be because of a totally different change in the environment for the student, moving, for example, from services provided in their typical elementary school to services provided in out-of-district private school. There are all sorts of things that could be changed, so reading that NORAP really carefully is super important. Parents, then, we've already kind of reviewed this, so I'm just going to move on from there, but I will say that we can certainly email out these materials, so if you have any questions about NORAPs and you want to kind of have a quick reference for how the 10 days work and what you need to do if you need to invoke pendency, this slide kind of lays it all out there, and we also have some articles on it as well on our webpage.
Okay, so we've been talking a lot about IEPs. So now we want to kind of go through the IEP because it's a really big document. It includes a lot. So we're going to go through the variety of components involved, and there are a lot there, and we don't have unlimited time. So like Jackie said, there are tons of resources on our website, articles, videos of other presentations. So if there's further information you need, you can always reach out there. You can contact us, and we'll put up our contact info at the end as well. But like I said, there are a variety of components in an IEP. The first is special considerations. So the special considerations are the different factors or special factors that an IEP team must consider before developing the IEP. So that could include if a student is blind or has a visual impairment, student is deaf or hard of hearing, if the student has communication needs, if the student needs assistive technology, if a student has limited English proficiency, if a student has behaviors that impede learning, or of course, the catch-all. So anything that the IEP team needs to consider from the outset when developing a student's IEP. The next is the present levels of academic achievement and functional performance. So this information is what comes when developing that initial IEP. This is going to come from that evaluation report. So it basically sets forward, where is the student right now? What are their present levels? How are they performing? So that when we assess progress later on, we'll be able to look back at those present levels and see how the student has done with the IEP in place. Transition services is another part of an IEP. And transition services are required once a student is 14. They can be included prior to that, depending on the student. And these look at transition services that would be helpful for a student following them leaving the school district, whether that be preparing to transition to college or preparing to transition to a job or a vocational program, looking at those independent living skills. This all varies depending on the student, but that's the point of an IEP. So these transition services should be individualized for the student and what that student is really looking for to do moving forward and how to best set the student up to achieve that. Another component of the IEP is participation in state and local assessments. So an IEP team must consider whether a particular student should participate in state and local assessments, or if there should be an alternate assessment they should be taking, if a particular assessment they shouldn't be taking at all, if there are accommodations in place for those assessments. That's one big area of discussion for an IEP team that is set forth in the IEP. Other components. So one important part of an IEP are the goals and objectives. So goals are the areas where a student needs direct instruction to access their education. And these goals need to be specific and measurable. So for instance, if a student has a specific learning disability associated with reading comprehension, the goal shouldn't be, student will improve in reading comprehension. Of course, that's a goal. That's a goal for all students. All students want to improve in their reading comprehension. A goal in an IEP for a student with a specific learning disability associated with reading comprehension needs to be specific as to what is it that student is going to try to do to improve in reading comprehension, and how is that going to be measured? What assessments are going to be given? How many, reading passages should a student be able to get through in a certain amount of time with a certain amount of look backs to be able to answer questions? It needs to be tailored to that student in a really specific way so that at the end of the year, or whenever the IEP team is annually meeting, you can look back at those present levels that we discussed earlier and see and measure the progress and say, how has this student been meeting this goal? Has the student met this goal? Should it be updated? Should it not be updated? Sometimes goals can also have short-term objectives as well. These are required for students with intellectual disabilities and for students taking alternative assessments, like I touched on earlier. Another component in an IEP are the special education related services, supplementary aids, and services and program modifications. So I'll talk a little bit more about what these mean in a bit, but these are essentially the accommodations that are put in place, or the specially designed instruction put in place for the student to meet those needs. So it can look like a lot of different things, and I'll go into more details on some of that in a bit. An IEP should also include supports for school personnel. So sometimes, depending on what a student's need is, school personnel might also require training, for instance, to know how to provide certain accommodations, to know how to use certain assistive technology. And if that's the case, that needs to be in the IEP. Another component of the IEP is extended school year services, which I'll touch on in a bit. And then finally, the educational placement. So this, Jacki explained earlier what the least restrictive environment is, or LRE. So the educational placement portion of the IEP will discuss what the student's educational environment should be, whether that is, and this should be the least restrictive environment. So that means being in the environment with that's least restrictive for a given individual's needs. For some students, that might be 100% of their time is in the regular education classroom with supports in that classroom. For some students, depending on their needs, for a portion of the day, they might need to be pulled out and put into a special education classroom. Some students might need their whole day in a special education classroom. Sometimes, depending on the need, some students might need to be in a completely different placement. And that this portion of the IEP will kind of make clear what percentage of a student's day should be in with general education students and what percentage should not be. So like I mentioned, specially designed instruction means adapting the content, methodology, or delivery of instruction to address the unique needs of the student and ensure access of the student to the general education curriculum. So this is kind of the bread and butter of the IEP. What specially designed instruction is needed for the student to make sure they are able to access their education. So part of this specially designed, part of this could include supplementary aids and services, which means aids, services, and other supports that are provided in regular education classrooms, other education-related settings, and in extracurricular and non-academic settings to enable students with disabilities to be educated with non-disabled students to the maximum extent appropriate. So again, that goes to that requirement for the least restrictive environment. So there are a ton of accommodations that can be in place that can be provided to a student in the regular education classroom. And these should all be included in the student's IEP. So some examples of that include study guides, preferential seating, testing accommodations, a one-to-one aide who can come to the general education classroom with a student. Any accommodation that a student needs in order to access that education would be included in the IEP. And
this is, oh, sorry, Rachel, I was just gonna jump in that this is one area for transition that I think also gets kind of overlooked. So sometimes I meet with families and they will tell me essentially that it was kind of predetermined that their child needed to be in a restrictive special education classroom for transitioning into kindergarten based on the transition meeting or maybe an evaluation that occurred. But what is often missing in that, for some students that might be the right answer, but for others who, may be able to be supported in the least restrictive environment with these supplementary aids and services, it's the trial of those things. So if we move right into that more restrictive setting without considering the less restrictive with the supplementary aids and services, that is an area that, there could be some issues with, and, parent may be entitled to have started the child in the least restrictive environment, considered all those supplementary aids and services, and only then, if they weren't working, move on. A parent shouldn't be told, well, it needs to be the autistic support classroom because we evaluate your child and that's what's appropriate for them, without any form of conversation about how to support the child.
Thanks, Jackie. So the related services, this is another component of an IEP that we touched on earlier, and Jackie mentioned a couple of these as examples, and I'll go through all of them. But the related services are services that are necessary for a student for the development of that student in school. And this can include a variety of different things, including transportation. So some students might need a specific type of transportation or accommodations on the bus or a special education bus. There are a variety of accommodations or services related to transportation. It could include parent counseling or training. It could include audiology services, speech and language pathology and therapy, psychological services, behavior intervention program, physical therapy, assistive technology devices and services, occupational therapy, rehabilitation counseling, other counseling services, interpreting services, school health services, orientation and mobility services, social work services, mental health services provided by someone other than the IU or the school district. So this might mean a student's private therapist being brought into the school district, or an entity outside of the school district coming in to provide those mental health services. And then of course, the ever-present other overarching category, it really could include any service that is needed for this student in particular, so that student can develop appropriately. Extended school year. So the IDEA Act defines the term extended school year to mean special education and related services that are provided to a child with a disability beyond the normal school year of the public agency, so outside of those 180 school days, in accordance with the child's IEP and at no cost to the parents of the child. And a public agency can't limit ESY services to particular categories of disability. So it can say, only students with an intellectual disability need ESY, for instance, and it can't unilaterally limit the type, amount, or duration of those services. So it can say, students with this disability require this much ESY. Again, the determination of whether a student needs ESY has to be individualized to that student. And Jacki spoke through some of the timelines earlier, but an IEP team, when they are making that determination, needs to look at whether the student is at a significant risk of regression outside of those 180 days. So obviously, when you look at, for instance, the summer months, most children might regress a little bit over the summer while they're out of school for 2 months or so. And the determination of whether that student needs ESY or instruction over the summer is whether that student has a significant chance of significant regression if they're not continuing to receive those services throughout the summer. So in that situation, a student would be entitled to ESY to avoid that regression.
Okay, just to kind of wrap it all up, the next part of our presentation is, what are you to do if you feel that your child's rights have been violated, or if you know of a child and you feel like they're not receiving appropriate services. What kinds of options are there? And the good news is there are several. So first is, when do you have to move upon this? That's within 2 years of when the violation occurred. So parents need to file for due process if they want to seek a remedy within 2 years of when they knew or should have known that the child's rights were violated. This could be a pretty complicated legal analysis based on what was known to the parent and what was known to the district at what time, and what was documented at what time. Bottom line is, because anything that isn't filed within the 2-year statute of limitations can be waived, if you have concern, I would seek help, and just have somebody review for you and let you know whether they feel that you have claims, so that you can make an informed decision about when and whether to act upon those claims. We do free consultations for clients. So clients can send in a child's special education records. An attorney will do a full review of the records and then meet with the family for a free 1-hour consultation. So if you're on the fence and not sure, really making sure you move within the 2 years after something happened. So like if 3rd grade was a really terrible year for a child, not waiting until 6th grade to explore whether there are claims is highly recommended. The types of options that are out there include a due process hearing. You've heard us mention that a couple of times. That's an administrative hearing where a hearing officer will decide for the parties whether there were violations of the child's rights, and if so, whether the child is owed a remedy. There's also mediation, where a mediator can help facilitate a conversation between two parties, or even take a more evaluative role where the mediator will kind of point out some strengths and weaknesses in the parties' positions. There's a lot of information in that procedural safeguards notice that families always get, but it's a lot to work through. There's also information on the Office for Dispute Resolution's website, including how to file for mediation and due process. Children with IEPs also, it's important to note, have special protections in suspension and expulsion. And they should not be suspended for more than 10 consecutive days or 15 non-consecutive days within a school district, within a school year. If it is more than 10 consecutive days, there needs to be a manifestation determination, because school districts are not able to take that action for something that is a manifestation of the student's disability, except for in a few very particularized circumstances. So, bottom line, this is definitely something to watch out for in terms of a child's rights potentially being violated if they're getting frequent disciplinary citations, if they're out of school a lot for out of school suspension or even in school suspension, or if it's not being counted as a discipline action, but the parent is still being asked to pick up regularly. And that is one that I see occur frequently, the transition from early intervention to school age programming, is that clients will be told, because of the student's behaviors, you have to come pick up your child. And that's really not appropriate, because the child is then missing the school day that their other peers are getting. They're falling further behind on learning. And really what has to happen is that the behavioral needs need to be addressed in a better way. If a family does choose to go to due process, the types of things that they may achieve for that are an appropriate program or placement. That could be like an increase in services. It could be a change in the type of services. If that the student has to be maintained in a less restrictive environment, if the LEA thought that a more restrictive one was necessary. It could be that the disciplinary determination is overturned. Parents can also be owed what's called compensatory education. That's a fund for students to make up for missed educational services. So if a student, for example, should have been receiving behavior support and was not, if the family can prove that, they may be able to receive an entitlement so that they can supplement the student's education going forward to kind of make up for some of that missed time. Parents can receive reimbursement for tuition for a private school placement that is meeting their child's needs if they were not afforded a placement that was appropriate for their child. And they can sometimes also receive out-of-pocket costs if they have been supplementing with tutoring or related services that were not provided and should have been. And they can receive their attorney's fees, which is important that this is a fee shifting statute, both the IDEA that creates the right for students with IEPs and Section 504 that creates the rights for students with 504 plans. They're both fee shifting. If a family is able to prevail at the hearing, their attorney's fees need to be paid by the other side. So we can open it up for some questions here for a little bit. Thank you so much for joining us. If you have other questions that you'd like to email, my email and Rachel's is right here, and we'd be more than happy to hear from you. Looks like there are no questions. Give it maybe one more minute in case anybody was trying to formulate their thoughts or type something up. Okay, well, thank you so much. It's really been nice to share this information. If you have any questions, feel free to contact us. And we hope to see you at another webinar soon.
Thanks, everyone.